of the charity, and they've got healthy and enduring relationships between them. And I'm asking that question because when I was thinking about what to do for my doctoral study, I could have approached it from the context of how do we end relationships well, because that's generally what I'm as a lawyer required to do. People approach me and say, we need to bring this relationship to an end, can you do it? And I'll either do it in the best legal way or I'll try and do it as well in the best relationship way. But that could have been a focus of my study, but I really wanted to come back and say, what about if we could avoid that? What about if we could bring it back to the point where we didn't have to have the relationship breakdown in the first place? And I don't say that as a criticism, but it's more of a desire of, can we do this in a way that's better and avoids the fracture and avoids the harm? And so when I start this, I wanted to start with a couple of case studies, and these are case studies that are actually decisions in the court. I certainly don't want to start with any case study from any of our schools, but these are decisions that have only just come down in the last 6 months, and so they're really helpful for us to actually say what went wrong and how can we have done things better. The first one is the Presbyterian Church of Queensland and Prescare matter, which was a very significant matter which resulted in the Presbyterian Church of Queensland through its care arm being placed into receivership and facing very significant financial liabilities as a result. So in that matter, October last year, we had the Supreme Court decision handed down, which basically said that the PCQ entity, which was a corporation, was liable to pay $32 million plus costs and interest. So it would probably be closer to $50 million at the end of the day. And this followed the entity being placed into receivership a few years ago once it was unable to meet the claims of its primary creditor, Catalyst. How did they actually get into that position? Well, the Prescare was in some financial distress back in 2017, and its financial lender was withdrawing support for it. And so, led by the CEO, the Prescare leadership, which was a sub-entity within the PCQ Corporation, entered into really novel and unusual financial arrangements with an organisation called Catalyst, which essentially had as its primary funder a superannuation fund. So they were quite non-traditional finance arrangements, which ultimately led to the PCQ Corporation and Prescare being unable to meet. And so one evening, late in the evening, and I was actually advising the letters patent office holders on that particular evening, the organisation was placed into receivership. And I'd probably say that was one of the darkest parts of my legal career, placing a large denominational entity into receivership. Catalyst then claimed various amounts owing, and the court looked very carefully at all of the governance processes that have been followed in approving the various transactions. They had regard to the size of the corporation, the experience of the leadership, the advice that it was receiving from various consultants, and the length of time spent negotiating the transactions. The receivers tried to argue that these processes were flawed, and as a result the arrangements should be set aside because the various parties making the decisions were acting in breach of their duties and in breach of their obligations as trustee. The court said no, they haven't breached their obligations. The transactions were not imprudent, hazardous or wholly unsuitable for this corporation, and so they ordered the PCQ Corporation to pay the costs and the amount outstanding, including indemnity costs. The proceedings have gone on appeal. We don't know where it's going to go, but what we do know is that a charity with a long history, with significant assets and credibility, has found itself in a position of receivership from which it may never emerge. Our senior staff were terminated on the way through. The CEO of Prescare brought his own litigation against the corporation. What we can say is that this was a significant and disappointing failure of governance. Now, second case that I've got a doll there, which I picked up at a little shop down in New South Wales. It's called the Dammit doll. I can imagine the governors when all of this was finally held, slamming this doll on the desk in frustration as to where they've ended up. Second case is a even more recent decision involving ASIC and Beckia, but it's actually the casino, Star City Casino decision. And so whilst it's in relation to a casino, there's very key issues that I think all boards can take out of this particular matter. This matter was really about whether the board had exercised their duties appropriately around money laundering and around protecting the organisation from becoming a party to money laundering. And it was also about whether the executives, and particularly the CEO and the Chief Legal Counsel, had exercised their obligations as officers around this money laundering. And in this particular matter, ASIC was arguing that they had not, and they brought these proceedings against the CEO, the Chief Legal Officer and 7 board members seeking pecuniary penalties. The CEO and the CLO were found to have failed to exercise their duties. They didn't escalate regulatory and compliance risks to the board, and so ASIC was successful in their case against those 2 particular roles. So who is that? In the context of your school, that's you as the principal, that's your business officers, business managers. And so ASIC was saying, you didn't escalate your concerns around money laundering appropriately to the board, and so pecuniary penalties will be passed on to those people. In respect of the non-executive directors, ASIC were unsuccessful because the court said that they had ultimately exercised appropriate judgment based on the information that was known to them. They couldn't be expected to look behind what hadn't been disclosed to them by the principal. So what they said for board members is that you are expected to have reasonable skills and standards, to ask the right questions, to be careful and diligent, but it's not a perfect duty. Making a mistake doesn't mean that you have breached your duty, and you're not required to invest yourself into operational matters. You're entitled to rely upon what management bring to you, unless you have a reason to believe that management is being dishonest or incompetent. For key leaders within the organisation, though, it's a lesson of escalating significant regulatory and compliance risks to your board so that they are aware, because ultimately you're responsible for a failure to escalate. You're responsible for what you fail to share with the board. And where does this sit within a school context? Well, I'd say that the key compliance risk is child protection. And how are you managing reporting of child protection? But it's also workplace health and safety, and it's also NASAB compliance, meeting the accreditation criteria. So those are the types of factors that you need to be asking yourself following this decision: how are we escalating that up to the board? So there are a couple of the case studies I wanted to start with to keep coming back to as we look at what it means to do governance well. What are some of the theories of governance? And as part of my early research, I've had to look into and been quite surprised to realise that there are actually theories of governance. Who would have thought? You'd think you just get on and do it. And I think that's what most of our boards do. They just do it. And you as principals, you just do it without understanding that there are these underlying theories. And by understanding the theories, you can also understand who are we as an organisation, what's important to us, and how does that therefore play out in our governance. Because the reality is there's a number of different approaches that you can have to governance that sits within your type of organisation. So one of them, firstly, is this theory of agency and the principle that you are stewards and that the governors are acting as stewards. In this setting, the board is essentially the agent of whoever owns the organisation, and for your organisation, the owners are essentially the members. And so the board acts as agents for the members. They act as the steward for the members, and their primary role is to monitor the organisation and the executive to ensure fiscal responsibility and prevent abuse. So that's this agency theory. I'm not sure if that necessarily fits within what is generally happening within schools, but it's helpful to understand. Certainly that principle of stewardship, though, is a key aspect from a faith perspective, that we are stewards of what God has given us, and we're trying to exercise that well. The other theory, which I don't think really applies within the school setting, is resource dependence, where a board is appointed really to find the best donors, get the best money into the organisation. That might occur with organisations that are largely dependent on fundraising. I don't think that's so much an issue with schools, which really are largely dependent on government and parent fees. And then finally, we've got institutional theory, and that's where the board's focus is on developing structures and processes to enable the governance in accordance with the underlying values. And in some respect, that is where some of our schools sit, because in recent years there has been this trend towards governing by policy, and that the board sets the policy and frees the executive up to govern in accordance with that policy. And I'll unpack that when it comes to some of the frameworks that we're talking about. Interestingly as well, there's been some commentary that I was finding coming out of the US, particularly in the hospital context, where the US obviously being quite significant with faith-based hospitals in the not-for-profit centre. And so this research is also dividing organisations into philanthropic and corporate. And I can see some similarities here with our schools. So the philanthropic approach is similar to agency theory, where there's a philanthropic purpose to why the organisation exists. And as a result, they've got a large board that seeks to meet that philanthropic purpose. They've got a large board that's also representative of the underlying stakeholders. So the stakeholders are appointing the board to represent their interests, and because of that, the board's focus is therefore on those interests of their stakeholders. What is the stakeholder going to be most concerned about? Well, it's going to be the values, how the values are being aligned with stewardship, how the organisation is acting out in the community. One of the other features of this, though, is that the executive has limited involvement with the board. The board really governs, and the executive is there at part to have some input, but the executive is certainly not a board member, not a part of the board meetings from a perspective of being involved in the decision making. Some of the research that I was reading was that these boards tend to make slower decisions. They tend to be risk averse because they're trying to protect the assets for the stakeholders, so they'll seek to preserve their assets, and they're also quite focused on the needs of their immediate communities. The other type of charity is a corporate charity. They have smaller skills-based boards. They really focus on management participation because they want to learn from management, be led by management, but they also want to hold management accountable in that process. And they're going to have a focus on strategic outcomes because they really want to grow. They want to achieve their outcomes similar to what a corporate organisation would seek to achieve. So the research suggests that these types of boards will tend to take calculated risks, they'll make quicker decisions, and they'll grow more rapidly through strategic acquisitions. But the converse to that is that the more rapid you grow, the greater you can fall, and the quicker you can fall. And so there's that concern as to, are they really exercising appropriate wisdom, or are they taking inappropriate risks in that growth? When I look at the various types of clients that I've worked with, I can see that charities that are representative of faith communities often come within that agency theory and philanthropic approach because it aligns with principles of stewardship. I do see, however, that charities that are government regulated or government funded will often come within institutional theory and corporate because they'll have to focus on structure and a focus on process to achieve their outcomes. And these organisations ordinarily have smaller membership, and that enables quicker decisions to pursue growth and expansion. Now, what I'm saying in all of this is that it's really important that organisations, boards and leaders understand what is it that's motivating us. Where do we sit within this type of research? What is important to us? Who are our stakeholders? What's important to them? And structuring your governance accordingly. Because if you're doing so, you're able to better plan for your governance framework, your role and your purpose, and in some respects, prevent unnecessary conflict. And then when I compare that back to the Presbyterian decision, I do find that it's difficult to place the organisation into any particular category because of the way that it was structured. It was so large, and it had an overarching organisation, which was the Presbyterian Church of Queensland, and then it had these sub-organisations fitting within it, one of which was Prescare. And it seems to me that in some respects Prescare was operating under a corporate which was management and insider-led. The management and the CEO were really leading the process, the strategic risk, willing to take more risk to achieve growth. PCQ, on the other hand, seemed to me to be more following the philanthropic model. Their focus was on community and stakeholder objectives. What are our churches wanting? What are our people within our churches wanting? And they would likely have been more conservative and unwilling to take risk. But then when I read the entire decision, it seems to me that most of the decision making was being done at the Prescare level, not at the PCQ level. And so there was a higher risk of tolerance at that level, what would have been a lower risk of tolerance at the higher levels. And I wonder to myself, what might have been the case if the philanthropic model had been applied in that context? Might decisions have been made in a slower process? Might there have been a more careful, considered approach taken? Might there even have been a decision to withdraw from aged care at an earlier stage to focus on other charitable activities? If they'd done that, they might have curtailed their losses significantly to what their losses ultimately became. And so I wonder if there was this misunderstanding of who we are and what's important to us at the various parts of the organisation that led to the ultimate decision-making and conflict. And so, sorry, I haven't kept up with my slides there. So I just wonder if for a few minutes, and we might only take a few minutes on this, maybe just having a little bit of a breakout, to ask the question, have you seen examples of these case studies in your school? What theory of governance, though, do you think your organisation or board or school comes within? What theory would you actually prefer to come within? And then how does your faith tradition actually impact on your school's approach? There's some of the questions you might want to ask in the breakout. There might be other questions you might want to ask, but I just thought it'd be good to take a little bit of a break and try to grapple with some of these issues. Right. Thanks, Dave. So hopefully that was an opportunity just to unpack some of that. It'd be great to be able to hear what you're unpacking together, but probably time doesn't quite allow us to hear from that, but maybe over morning tea we can have that discussion just to share with each other what we've been reflecting about. Right, well, from here I really wanted to move into asking then the question that there's clearly issues that we need to address, and the question that I had then was, well, do the structures and obligations that I guess the government imposes on us, or the community or other commentators impose on us, are they going to help us in dealing with these issues, or is something more needed? And so I went to, from a legal perspective, what are the obligations that are placed upon us as organisations?
Sorry, you can keep talking.
No, that's okay.
Don't mind me.
And so what are these obligations that are placed upon us? And so then I started with the most basic, and it is actually the most basic, and that's what the Australian Charities and Not-for-Profit Commission says you have to be doing as an organisation from a governance perspective, and that's the 6 governance standards. And so I've set them out there. Charity has to be not-for-profit, working towards a charitable purpose, must be accountable to its members, must comply with the law, must ensure that the leaders are not disqualified from being a director, must ensure that the leaders meet the duties that are imposed on office holders, and we talked about some of those duties at the outset in the case studies, and then must maintain and enhance public trust and confidence in the NFP sector. And that number 6 is a fascinating one. You think that could do almost anything, but then the government says it only has one object, and that is to require you to sign up to the National Redress Scheme. That's it. And so it's interesting that they've come with Governance Standard 6 and they say that only applies to the redress scheme. Once you've signed up to the redress scheme, you've complied with your obligation there. What we do know about these is that they are brief, and they're purposefully so. They're meant to be a minimum standard of expectation. You meet the minimum expectation and therefore you've complied with your obligations with the ACNC. And the ACNC also say that really our focus is on education. We're not really focused on enforcement unless education is not working. And so when we even look at enforcement, we don't see a lot happening from the ACNC. Probably the most recent thing that I think we've seen is some enforcement undertakings entered into with Hillsong College. That's probably the most recent example of enforcement by the ACNC, but essentially they focus on education. Certainly these standards don't address accountability, transparency between the board and the CEO, relationship between the board and the CEO. At best, they talk about the standards having accountability to the members, but that's really about transparency with members and holding an AGM once a year. So that's not likely to have all that much impact. When it comes to meeting office holder duties, the obligation is imposed on the organisation to ensure that the governors meet their duties, but that doesn't necessarily prevent an unwise decision being made. In fact, the receivers for the PCQ Corporation argued strongly that there had been breaches of trust and breaches of duty by the various office holders and leaders. And in that case, despite the leaders committing the organisation to complex, novel and non-traditional financing that would cause significant harm and loss, Justice Bradley concluded there had been no breach of duty. So the governance standards aren't going to get us there. They go a very small part of the way. They'll allow you to meet your legal obligations, but they're not going to really facilitate joint wise decision making or healthy and enduring relationships. The other one that's it hasn't come out of government or any corporate commentator, but has come from the US, is policy governance. And this was promoted from the early 2000s by John and Miriam Carver. Maybe you've read the book or followed policy governance to some extent within your organisation. And so policy governance is essentially responding to the concern that boards focus on the trivial and immediate rather than what actually matters, which is strategy. And they need to allow the CEO to deliver outcomes, facilitate the CEO to do that, but hold the CEO accountable to the delivery. And so with a policy governance approach, the board's primary focus is to promote policy, to create policy, and that those policies will start broadly, so they'll focus on strategy, role and responsibility, and they'll gradually narrow down in focus, so that by the end of it, the policy should have covered off pretty much everything that the CEO needs to do. So the CEO just needs to make sure that he or she is complying with policy, subject to any express limitations that the board places on the CEO. And within the context of complying with policy, the CEO has very broad discretion in the operational management of the organisation. I think this approach fits best with institutional theory and the corporate model, given that it's got that focus on structure, policies and accountability. And various commentators all say that this approach is the best approach to do, that it allows for a board that focuses on vision and strategy, and allows for a CEO to focus on the outcomes of that. It does, though, place significant decision making in the CEO, and when significant decision making is placed in the CEO, it places significant accountability for that decision making in the CEO. And so whilst it can result in organisations being quite successful, it can result in better relations between the board and the stakeholders and the CEO, it does assume that the organisation will be successful. My concern is that when the organisation has some form of failure, relationship breakdown is at real risk in this model. And ultimately, with that relationship breakdown, the CEO or the principal is the one held accountable because all of the decision making has vested in the CEO. I also think that the benefits are somewhat illusory because it's dependent upon a trusting relationship between the board and the CEO. It's also dependent upon a competent and effective CEO and a board that's actually going to be willing to limit its role to policy development and accountability. The difficulty in that approach is that it hasn't really kept pace with where we are from a regulatory environment perspective. The last 15 years, 10 to 15 years particularly, has really increased the regulatory expectations on boards out of the various royal commissions, the Sexual Abuse Royal Commission for Children, the Aged Care Royal Commission and the Financial Royal Commission. All of those said that boards need to be far more involved in the organisation and the culture of the organisation and ensuring that the organisation is led in accordance with that. And so if boards are simply developing policies and expecting compliance with policies, it raises the question, are they really fulfilling what the regulatory bodies are expecting from the board? Again, when I come back to the PCQ decision, it seems to me that Prescare was operating certainly under this model. The CEO had significant authority, with certain decisions requiring input and approval of various committees, and particularly for the Finance and Risk Committee. But it also seems that Prescare, led by the CEO, were driving the negotiations with Catalyst, with the assistance of third-party consultants. So it raises the question of how involved the board of PCQ was in the decision-making, and specifically whether they were a key part of the discernment process. And so some of the research that's coming out of particularly the US is saying that boards need to consider itself as the guardian of the organisation. They need to be involved in key decision making, ensuring that the organisation remains aligned to mission. That requires a mutual commitment between the board and the CEO to information sharing, facilitating a safe environment in which to raise questions and disagree. And so the question is, does that type of environment align with a policy governance approach? And I think the difficulty is that it doesn't really align with it. The PCQ decision also demonstrates vulnerability when it comes to enduring leadership relationships. As I said, when the organisation is leading and functioning well under the leadership of a competent CEO, there's likely to be healthy relationships. But when failures occur, relationship quickly breaks down, and that's evidenced by the CEO in the Prescare matter bringing his own litigation against Prescare following the termination of his employment. The other principles of governance that are commonly being adopted by charities comes out of the AICD, and the AICD seeks to strike a balance between the policy governance but also a board having more input into the organisation. And I think they are certainly getting towards where that balance needs to be, and it is a helpful resource. It's available online for free, and so I'd certainly recommend that you have a close look at it. They really focus in on governance principles. I've got some of those there, that the board should be focused on purpose, vision and strategy. The CEO, though, has authority, but that's balanced by accountability and the role of the board to be inquisitive. They also talk quite strongly on the board being diverse, representing a diverse group, both from a gender but also ethnic perspective, because with that diversity, the board is able to see in a broader way and have input in a broader way. Also talks about the board having risk and organisational performance oversight. They introduce the concept of sustainability, but not just from a financial sustainability perspective, but also an environment sustainability, a social sustainability and a human sustainability. And then they talk about the importance of the board and the leadership modelling culture for the organisation. So there's certainly a good expansion on where we've seen policy governance be. I'd particularly urge the focus on diversity as being a welcome inclusion. The research is fairly clear that diversity on boards does help boards be successful, does help them better focus on what they need to be focusing on and bearing in mind all of the relevant factors. And so if your board's not a diverse board, there's an opportunity to think about that when it comes to replacement of board members as to how can we be more diverse, how can we have more gender on our board, more ethnic diversity on our board. The importance of organisational culture as well is really important. Holding management accountable to this culture is an important inclusion. There's a recent book you might have read by Judd, Swinton and Martin around keeping the faith, and they talk about the importance of boards developing statements of organisational theology. The board that I'm on with Baptist World Aid, we went through and created statements of organisational theology from all of the various perspectives. We've got a statement on theology for risk, for example, because risk in our organisation is significant. We need to understand how we're going to handle risk from a theological perspective, not just an organisational perspective. There's another really interesting book that's also out of the US called The Church Called Tove. I don't know if you've read that, but that's focusing on church governance and high-profile church leader misconduct. And they note the importance of a board being committed to truth, accountability and justice, regardless of the cost. And another author, Parker, talks about boards being driven by integrity, honesty and professionalism. And the board needs to set those expectations from the top and drive it down through the organisation so that all individuals within the organisation consistently live out these values when interacting with others. I think it's vital for flourishing organisations to have clear expectations and for boards to act promptly in response to that. So while the AICD principles are a comprehensive summary of the board's legal and ethical obligations in governing an organisation, I still think there's no guarantee that when you follow these, you're going to avoid what occurred with PCQ. Prescare and PCQ had various levels of governance. They included qualified and experienced governors. They obtained advice from third-party consultants who were very reputable. Decisions were still made that resulted in significant loss. And so whilst the principles do provide a helpful and more detailed governance framework, I think more is required, particularly from an ethical and spiritual perspective, as to how are we going to govern both ethically and spiritually. How are we going to discern well to make sure that we're making decisions that we're being led to in our Christian faith. One of the other interesting thoughts was, well, why can't we just do away with boards all entirely and just outsource boards? And so there is some interesting perspectives on that. I think we are starting to see a little bit of that even here with very corporatised boards. But again, I think the real problem with just outsourcing a board is that you fail to have the relationship that you can have between the CEO and your board. And the key is that we want to be building strong and enduring relationships. And so it's out of those relationships that we make the wisest decisions, because the council of a broad group of people all committed to the same vision and mission is what is best able to protect us and to be making wise decisions. So maybe we might just have a further bit of discussion. I don't think the breakout rooms are probably still working. I'm not seeing any signs that they are from Ethan or Dave. So we might just have a little bit of time of just reflection, and maybe within the groups on the online, they might be able to just do it together online without being fed into this room. But then within your group, just to ask the question, is there a model that you are using? How have you observed it's operating? What can you celebrate, but what are the tension points? And in your ideal board, how would you want to see the board and the executive operate? Maybe we take just 5 minutes on that, if that works. Great. So, some reason the slides... I'll just get us back to where we were. Right, so as I was saying before, it seems that the principles of governance are somewhat insufficient. And so some of the things that I'm starting to think about is how do we get to the point where the CEO and the board, the principal and the board, see themselves in partnership and collaboration? How do we achieve that? Is there a value in achieving that? And also, what about a discernment process? What might discernment look like within a board that really wants to grapple with the principal, the CEO, on these significant issues, that wants to make careful decisions? And what are some other practical strategies we can use to build trust and unity? Is education and training sufficient? Is something more required? And part of what I've been really focusing in on, which I wasn't expecting to focus in on when I started this journey, was around contemplative practices and contemplative retreats, and whether that might be something that might assist boards in developing relationship and unity and trust. So a board in partnership and collaboration, what would that look like? The governance framework contemplated certainly don't address this level of partnership, nor do they include practical steps to achieve it. Some authors are talking about the need for a relationship between certainly the chair of the board and the CEO so that they're working effectively together. Again, studies coming out of the US in the hospital context had a particular study in the relationship between board chairs and CEOs, and how those relationships led to better hospital financial performance. Their assessments were that where CEOs are intimately involved in board decision making, whether the CEO has a voting right or is a passive observer, but if they're intimately involved, it's a better outcome for the organisation. They also showed that boards with board participation and CEO participation had better operating margins and performance. They concluded that involving the CEO in the board considerations led to the inclusion of managerial acumen, strategic insight, and that actually helped hospitals adapt to uncertain and changing environments. I think CEO board involvement is a common reality for our boards today, whether it's ex officio or with voting rights, and that depends upon the organisation. There's always going to be a need for a CEO or a principal to exit the room where there's a conflict, but I do believe that organisations benefit from having the CEO actively involved at the board table as a part of the decision making. What's important is ensuring that there's mutual trust and confidence between the two parties, each respecting and accepting the other's role. Matthews, one particular study in 2019, she focused on the relationship between the board chair and the CEO, and noted how that relationship was critical to the organisation's functioning. But she also noted how role clarity and alignment was critical, that there needed to be frequent communication between the two about who was doing what in order to achieve that sense of partnership and teamwork, who was responsible for what, where the roles differ, and that clarity is essential. She was suggesting education on role clarity, but in some respects I think it's more than education. Education only goes so far. It's about how do we put it in to practice. So that first issue around building that partnership level. Secondly, around building a process where there is this joint discernment between the board and the CEO, or involving the board and the CEO. When I look back at the Prescare decision, I can see that there were a significant number of decision makers involved. There was advice being taken from various consultants, but I can't actually discern whether there was a careful, considered discernment process with all of the decision makers, whether done individually or in collaboration, but whether they discerned what was the direction that they should be taking, but also discerned what was the alternatives, what else could they do rather than the path that they were taking. One particular author I was reading noted how it was so important for boards to take time when making important decisions, and that's actually a joint obligation. It's not just an obligation of the board to slow down, but it's an obligation of the principal or the CEO to also slow down, not to expect rushed decisions. The board needs to give the principal or the CEO the time needed to properly research what was required, where the matter should progress. And then likewise, the CEO needs to give the board the time to process the information and make a decision. And those decisions don't need to be made within the context of one meeting. It may take multiple meetings in order to make a carefully discerned decision. One book that I was reading I found really helpful on this, although it probably went a little bit over the top to some extent, was Ruth Haley Barton's book on discerning processes for boards. She takes the process a lot further when she seeks leadership to jointly discern God's will and avoid decision-making based on personal wisdom or usual corporate approaches. So her approach calls for the board to have a mindset shift from being just based on organisational practices, what the governance principles might say that you need to do, to shift away from self-protective behaviours, posturing behaviours, and to become a spiritual community that's committed to love and service. And so when she says you're making significant decisions, she argues for actually a planned discernment process, a process of corporate prayer and individual prayer, including what she calls prayers for indifference. Lord, let us have an indifferent approach to this so that it's not our decision but your decision. A process of mutual listening to each other, to adjourn, to step away from the meeting room, to embrace silence and then allow an inner peace to form led by God. I think that approach can certainly form part of a broader framework for organisations where the board and the executive prioritise joint decision making that values the input of all involved at the table, setting aside their own preconceptions, their own biases, and engage in silent reflection both before, during and after decision making. So that, I think, is actually what we're called to when we're being asked to be led by God, given that we are stewards for what is ultimately his mission. I think as well the benefit for taking this type of approach is that it likely will build trust and relationship and lead to better decision making. Boards engaging in this approach will be willing to actually hold attention rather than seeking to be uncomfortable with the tension and wanting to make a decision hastily. Instead, hold on to that tension and ask ourselves, in the tension, how can our decision making be improved? I do appreciate as well it leads to longer decision making times, and that's going to frustrate some, particularly some board members or the CEO. And so there needs to be an understanding of when does this type of discernment process step in and how do we engage with that without frustrating each other, but also acknowledging the importance of discernment. The final area that I'm very interested in is contemplative retreat. I've been on quite a lot of board retreats in my time serving on various boards, but I can't really think of a time when I've been on a board where they've been involved in contemplative retreat together. And I actually had the benefit as part of my study to do audit a subject on leading groups in contemplative retreat. And as part of that, engage in a contemplative retreat together. And I used part of that learning and process to actually take my board at Vocare on a contemplative retreat within a board meeting perspective to see how it worked. And I did get the sense that, yes, there is some real benefits here to actually shift our retreats from being business only to actually becoming times of contemplation together, to gain a deeper understanding of each other, to deepen our trust with each other, and then to potentially have this shared experience together as a group that we can draw upon when we're needing to make difficult decisions on something that might arise down the track. I haven't found a lot of study on this, and so I'm keen to research this more. The only real study I found was within a university in the US where they used contemplative retreats within the entire faculty over a period of 18 months. They had 35 faculty members participating in contemplative groups together. And they certainly reported back an increased sense of community through the shared experience and improved interpersonal relationships. And so I wonder what that can look like within a board context if we actually find some time, whether it's within board meetings but outside of board meetings at retreats, to contemplate together, to share together, to learn more about each other within that process. And so that's certainly one of the things that I'm quite keen to explore with boards. And so I want to finish with this particular image that I saw. I was out walking in Katoomba last year, and I came, but some of the reflection questions I had for us coming out of this last bit, what's the level of partnership and cooperation between your executive and the board? Is your board a receiving of information board? Are you a decision-making board, or are you a discerning board? Could you see value in contemplative practices both within your board and more broadly? But what other strategies do you think you can be purposely adopting to increase unity, trust and wise decision making? Thanks.